Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me, as always, is my co-host, Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. How are you?
I'm fine, thank you. So, Sam, today we're doing, as you know, a two-part episode. So we're going to break this up into two different segments, and the reason we're doing that is because there's a lot to say here, and I don't want to skip anything that's important.
Big important topic. Yep.
Right. And what that topic is all of our topics are important. Otherwise, I probably wouldn't waste my time with them. We're going to be talking about HOAs and disabilities. Members with disabilities, what are their rights? What constitutes a disabled person within the meaning of the Davis-Stirling Act and federal and state law? When are HOAs required to provide accommodations? What type of accommodations are required to required to offer or cooperate with? We're going to cover the whole gamut. Now, there's one aspect of HOA-related disability that we're not going to cover other than in really big passing today, because we have done one other episode entirely on that one aspect, and also on the website, I've got at least one fact sheet and at least one article dedicated to this one other issue, and that was service animals and emotional support animals. Okay? So we're going to mention that maybe once during this two-part episode, but we're not going to go into detail there because we've got dedicated episodes already for that and articles up the yin-yang.
That's right.
So we're going to leave those out for the most part, other than to mention it when it's relevant. Okay? But let's start today then with, I think we're going to do this in a logical order. Let's start with the real-world problem that homeowners face. And disabilities, as you'll come to see, what constitutes a disability, it does matter whether or not you're looking at federal or state law. But since we're in California, state law applies as well. And California state law, as we talk about later, is a lot more broad in how it defines disabilities, meaning a lot more things are considered disabilities within the meaning of our laws.
That's right.
And so they would apply to HOAs in California more so than even the federal law would allow. And then as part of that analysis, therefore, we're going to talk about the types of the disabilities that qualify and how those translate or appear in the real world. Okay? Now, the thing about disabilities and providing accommodations for disabilities in an HOA context is that when you're talking about a good HOA, and there are a lot of good HOAs out there in California, we're the first to admit that, things work real smoothly. It just never, people are kind to each other, and it kind of just works out because the HOA, the board in particular, recognizes its duty and kind of follows California law on that, and it just kind of works itself out. And there's never, you look at it, if you live in one of those good HOAs, and you can't imagine why this is an area of such dispute. But in bad HOAs, and there are more bad than good, this is one of the most common, when there's disabilities involved and you live in a bad HOA, there's going to be a lot of disputes regarding these because it seems to center around the types of people that are operating these bad HOAs seem to really don't dislike disabled people when it comes to providing any sort of accommodation.
Well, it's oftentimes a function of the prism through which these boards operate.
Yeah.
It shouldn't really not be a contentious issue in most instances.
Because it's never.
But there's mistrust. There's this hostility, unnecessary.
Us versus them, yeah.
Exactly.
Exactly.
It's not the right temperament to be.
These disputes regarding disabilities and disability-related accommodations rarely start right at the beginning as legal conflicts.
Yeah.
Okay, let's get that straight. But they are always, and this is where they start, is everyday practical problems. So here's kind of where you see this a lot. You see it, a homeowner needs a closer parking space. Yep. They've got some mobility issues, whether it's chronic arthritis or they're in a wheelchair or they've got they've got a missing leg, whatever it is.
Fibromyalgia, MS,
right.
Could be a bunch of things.
Some sort of mobility issue, and they need they need a closer parking space. Or you might need a resident who needs, here's where we're going to talk about the pets for a second, right? Even though service animals aren't pets, but we'll call them pets. You might need a service animal or even an emotional support animal, and therefore might need an accommodation with respect to having the pet in a location that isn't normally
That's right.
where pets or animals aren't normally allowed to be. Or you have someone ask for a ramp or a handrail in the common area. Or in some situations, more so in, let's say, condos, they might need to do some sort of structural change in their actual unit.
Right.
Even though it's their separate unit, it requires...
Like a lift.
Right.
Yeah.
Exactly. And that would require permission from the HOA, and there's obligations there. And that's where we see these things, okay? Now, from the homeowner's perspective, these requests are they're not political.
No.
And they're not strategic.
Right.
They're purely practical, right? I need this to make it easier for me to function with whatever disability I happen to have.
Right.
And so they're always about basic functionality, getting into and out of their own home safely, moving through or within their own homes, inside getting to their second story, let's say, in the case of a lift, getting, no other units have an elevator or a lift, but this person might need that, okay? Using common areas without unnecessary barriers. So from the HOA's perspective, right, I think you'll agree, these, at least from a bad HOA's perspective, these requests come across as, well, this is rule breaking, or you're asking for special treatment.
That's right.
Well, yeah, you are. That's okay. Or it's favoritism, or it threatens, uniform enforcement. That's how bad HOAs view these, as opposed to what they really are, which is, I need an adjustment or accommodation of a rule or some limitation in order for me to be able to access my property in a way that's comfortable for me or
safe.
Or safe.
Safe.
Yeah, in many cases
whether
safe.
it's a separate interest or common areas.
Yeah,
Safety.
exactly.
Yeah.
And also a lot of boards that aren't well managed, so we call them bad HOAs, right?
Sure.
Are they default to what's comfortable, what they know. They default to the norm because it's easier. Okay, so if they look at, let's say, well, our governing documents say that parking is first come, first served, and you're asking for, you just got here, and now you're asking for the primo parking spot. Well, you're asking for it because it happens to be right in front of your unit.
That's right.
And you have mobility issues, right? But they see that not in that way. They see it as you're looking for special treatment. You're looking for us to violate our own governing documents, and we're not going to do that because we're the gov.
And that's a wrong and incomplete lens. I mean, should you consider that? Perhaps, but once you have a request of this nature, don't operate from a place of just being fear-oriented, being combative, and mistrust.
Or strictly, or looking at the governing documents as being sacrosanct. Governing documents are sacrosanct unless there's a valid exception. And one of those valid exceptions is you have a person with some sort of disability that requires a modification.
That's right.
That's okay.
And this is where a lot of boards run afoul of this because they're so fear-oriented that there'll be unintended blowback consequences that will get them in trouble for selective enforcement, favoritism.
Exactly. You know what you hear along the lines of what you just said. You hear, if we allow you to do this, we have to allow everybody. No, because not everybody's blind, or not everybody's in a wheelchair, not everybody has fibromyalgia, or whatever. No, that's not the way to look at it. But that's what gets these bad HOAs into trouble. It's that mindset. So disability accommodation cases, right, expose fundamental tension in HOAs. That is a source of tension, and that's kind of what this episode is going to be discussing, okay? Disability laws, by their very nature, require flexibility.
They do.
Okay? They require the type of flexibility that a good HOA, or that comes very naturally to a good HOA, a well-managed HOA with even-keeled, psychologically normal board members.
That's right.
Have no issue with understanding the nuance between somebody that requires some sort of accommodation, somebody that doesn't.
And heightened good faith. Heightened,
right. Yeah. And when boards fail to recognize the distinction between a request for favoritism or special treatment versus I just need to be able to function, okay, safely, they respond often, and this is in the case of a bad HOA, they respond defensively. Again, we've talked in the past about bad HOAs. One of the things you find in bad HOAs are board members with egos. Larger egos than they ought to have if they're going to be serving as volunteers, which is what they're supposed to be doing, right?
Well, the wrong temperament often, and I would say invariably, leads to wrong impulse, right, on these issues.
100%.
Yeah.
I agree with you completely. Okay? And so that's the tension that is at heart with everything we do here. And when that tension is present, the result is predictable.
That's right.
Okay. Homeowners feel dismissed or targeted. Conditions worsen. Conflicts escalate. That's what happens. What could have been resolved early often will turn into a formal dispute, and those disputes have legal consequences. And that's why we're talking about this today. That's where we come in.
Yeah.
Because California law, and we're going to get to this later, folks, because California law strongly protects disabled homeowners in housing, HOAs that mishandle those requests are exposing themselves to tremendous liability. And it's this issue which explains why we're starting this episode really at this point. It's why we're starting at this point for this reason. Because before you can understand what the law requires or how to enforce it, you have to understand why these disputes exist in the first place.
Agreed.
And that's what I think we've just done a pretty good job of discussing. Because these disability/accommodation cases are not what we call edge cases.
They're not.
They're not wobblers. They're structural pressure points where a bad HOA or bad HOA governance reveals itself quickly and clearly. And with that in mind, having understood that, we can now go maybe a little backwards and say, okay, what's the law?
Right.
So let's start with the law.
Let's do it. Okay.
Before getting into what an HOA has to allow in terms of accommodations, because that's really what this thing is about. Right. If there was no need to accommodate, then if there was no need for permission to do something, then there would be no need for an accommodation.
It'd be self-executing or operative. Yeah.
It would just be. It would just be. So obviously, everything that flows from here onward is because there's something that somebody with some sort of disability needs that is not just automatically permitted or allowed or, easy. There's some accommodation that needs to be made, hence the word accommodations, okay? And so before we can get to those specifics, we got to kind of handle, okay, what is the law here? And there are three, I guess, legal frameworks that matter here. One of them is federal. We'll talk about that in a second. One of them is, two of them are state, but one of them is federal. One of them is state, but not relevant necessarily to HOAs only. It's much more broad. And then the third is the Davis-Stirling Act, where it's actually, as listeners to this podcast know, only relates to HOAs. So the three legal frameworks in California that we're going to discuss that underpin all the disability stuff we're going to be talking about in these two episodes. One of them is federal law. One of them is state law, but much more broad than HOAs. And then the other one is specific to HOAs. And with that in mind, let's start with the two specifically discrimination laws, okay? And those are the Federal Fair Housing Act, which we're going to refer to, because that's a mouthful, we're going to call that the FFHA, Federal Fair Housing Act. And by nature, it's federal law. That means it applies to all 50 states. Okay? And the second Anti-Discrimination Act that we're going to talk about, that second framework, is the California version, I guess, of
the counterpart.
California's counterpart to the FFHA, which is called the Fair Employment and Housing Act, or we'll refer to it from now on as FEHA. We're not going to say Federal Employment and Housing Act over and over. We're going to call it FEHA. So federal is FFHA, and California is pretty much mirror of that, but you'll find out it's much more broad, so it's not really a mirror. It's a lot more involved, but that is FEHA. And then, of course, you all know what Davis-Stirling is. We'll get to that later. So let's start with FHA. The FFHA. So under the federal law, the FFHA, HOAs have to make exceptions, right, to otherwise enforceable rules, Sam, right? These rules are we're gonna already state, these rules are enforceable. However, in this person's case, they need an exception.
That's right.
And that's where FFHA, the federal law, comes in. So let me why don't you give an example? Give the first example. Talk about a parking space for me.
Well, you alluded to this earlier in our general, foundational or preliminary comments. But basically, someone with a disability that limits their mobility or access to, let's say from where they park their vehicle to their home, and they submit or lodge a request with the association for a more proximate space.
It could be a bunch of things. It could be modification to their space or their garage, or it could be I need a closer parking space.
Space. It could be like curbside, but in a way that's more closely proximate to their home and their garage, so that they have access for their, let's say, ramp or wheelchair access.
Let me give an example. I'll give 2 examples. Okay.
Sure. Yeah.
Let's say all the units have garages. Okay, and you'll see this in condos and single family homes, of course. But let's say all the units have garages. And let's just to make it the example more realistic. Let's make this a multi-housing complex, like a condo complex. Okay? Mm-hmm. So all the units have a private garage. It's not like a big underground parking garage, but they all have a private garage. Mm-hmm. And you've got a person with a oversized vehicle. Mm-hmm. Let's say a van that has a lift for the wheelchair to go up and everything. And of course, that does require a good deal of space on the side, usually, sometimes the back, but usually the side, it requires a good deal of space to actually function.
Yeah.
So a lot of these let's say in a lot of condos, you'll find these single car garages that are too narrow on each side of the car to allow that. If the other spaces that are not in the garage are open spaces, somebody might some disabled individual with, let's say, one of these vans might request an assigned parking space in addition to their garage, where everybody else, it's just first come, first serve for their guests or residents who live there to park in these open spaces. They might say, look, I can't pull my van into the garage. It's too high, or the garage is too narrow to allow my lift to work. I wouldn't be able to get out. And I need an outdoor space. And they might say, look, I know those are all open, but I need one that's reserved for me.
Yeah.
That's the kind of accommodation
good example. Yeah.
that the law would almost certainly require, when it comes to parking. Here's another example. You brought this up already. Proximity. Let's say when you buy into into this condo complex, it's kind of first come, first served, and that you're not necessarily guaranteed a parking spot close to your unit. You might have a 100-yard walk or 50-yard walk.
Yeah.
You might have somebody say, wait, my unit's located over here and I've been assigned this parking spot over here. And in those cases, and you'll see this in a lot in condos where the parking space doesn't actually come with, the right to a parking space comes with the membership, but not a specific space that's owned by the unit.
Yeah.
And so they might say, look, I need a different space. I need one closer to my unit. I'm in pain. I can't walk these distances every day, twice a day, or 3 times a day, or however often I have to get to my car. It hurts to walk. I need this. That, again, federal law, FFHA, might actually require that sort of accommodation. Right. Yeah. We'll cover that later when we go into accommodations, but that's kind of what we're seeing here, okay?
Right.
This is under the FFHA. These are the kind of scenarios where an HOA would likely have to make some sort of exception.
Yeah.
Another example is service animals and emotional support animals. Okay. And again, for the specifics, go to our other episode. We did it, or multiple articles and fact sheets on our website, where we talk about the specifics related to what an HOA can and can't do with respect to a service animal and emotional support animals. Those are different. Service animals get a lot more protection on the law than emotional support animals, but they're both considered non-pets. And so those kind of accommodations are going to be required under the law, just period, required. Or you might have a situation where, I've seen this before, in again, usually multi-floor condo complexes where they have elevators or access hallways that might be time limited. Certain elevators are only operational during certain times. You might have to make an exception and have that space made available to a disabled person beyond the hours that are normal hours, either because the alternative, it is either too far for them, or for some reason, is painful or causes a problem, and this elevator is more convenient, given their mobility issues, that sort of thing. So I could see that happening, right? Under FFHA, an HOA might have to permit a homeowner to make physical changes to the common area. Now, that's virtually unheard of in any other scenario. Even when we were talking about security cameras, we were very clear to say, you don't have a right to put a camera up in the common area or a Ring doorbell. They can say no.
Yeah.
But here, they might not be able to. Give me a scenario where a homeowner, disabled homeowner, might need to say, look, I need to make a change to the common area.
Let's just say it's some kind of a elevated platform or like a curb that needs to be either taken off or, I guess, removed.
You mean a ramp thing.
A ramp, right? Or to accommodate a ramp or to accommodate easy access to a vehicle, right?
Right. So let's say their parking spot, they got a street parking spot designated to them because they don't fit in their garage, right in front of their unit.
Yeah.
But the nearest, whatever those driveway rampy things is, 100 yards away, and they're going to have to roll 100 yards or 50 yards to get up there. Maybe they might say, look, I need one near the van so I can come out if it's raining or whatever. I want to be able to come up on the sidewalk and get to my unit.
And whether that's pure common area or exclusive use common area, even pertaining to your home, nonetheless, that requires the HOA to work with you.
Right. In the case of a ramp, it would be common area. There would no way a sidewalk is going to be exclusive use. But that's a great example, is you might need to build me those little mini driveway things so I can roll up onto a curb. Another one I could absolutely see is if your unit is on some sort of elevation that has either a ramp up to it or both, a ramp and some steps. Right. You might want some sort of hand railing.
Hand railing, yep. That's a common one. We see that all the time. Now, they can charge you for the expense of it.
That goes without saying. Yeah. On every situation where you are asking for an accommodation to modify the common area, the 100% of the costs are going to be paid by the homeowner.
By the applicant, yep.
Yeah, 100%. They're going to be paid by the homeowner. The HOA is never going to be obligated to fund it itself.
And they can also require you to maintain that, essentially, at your expense.
Yes.
Right? So that notwithstanding, that removes impediments to the association working with you to accommodate you.
But you would be in such a scenario in a position to say, you need to let me put this handrail up.
That's right.
And the HOA really is going to have a hard time saying no. Now, they can make sure that it's done by licensed contractors, and it's done according to building codes, all the stuff that they clearly have a right to regulate. You can't do a ship-shot job of doing it, but they're not going to be able to say, nah, nobody else has a handrail and it looks bad.
Right.
Or no, we're not going to build a ramp here because everybody's going to want a ramp. Everybody's going to want a ramp that's convenient for them. Well, everybody doesn't need a ramp, so that's not going to fly.
Right.
But I could see that happening, okay? Or even, you brought this up, I think, before when we were just chatting about this issue. In your own unit, where you generally have a right to do whatever you want, unless it's structural. If you're in a condo and you're doing something structural, yeah, you got to get permission.
Right.
But if if you want to paint inside your own condo or you want to add rails, you never have to ask your HOA for that. Doesn't matter. You can do what you want. But what if it's a significant change? Like, let's say you want to add
a load-bearing wall. Let's say.
Yeah, you need to add a lift
to do lift
to get to your second floor. You want to add one of those elevators in your condo. You might need to go to your HOA for that, and they would need to. That might be a place where they would have a very hard time saying no to that accommodation. Again, you're going to pay for it, and you're going to have to indemnify and insure in case you do something while you're constructing that damages another aspect of the common area. But you might need I could see them.
And some of the reasonable things they may require of you is, again, you pointed this out, that it be done by someone who's licensed and all of that, but also passes, let's say, building safety code and code enforcement.
Oh, that goes without saying. You're going to have to get permitted.
And that's reasonable.
Yeah, of course it is. Of course it is. Okay. So these are kind of a couple of scenarios where the federal law, the FFHA, would probably compel, in the ways we're going to talk about later, probably compel an HOA to change the rules, make accommodations.
Right.
That's federal law. But the FFHA has limits.
It does.
Okay. And that's where California law, which is significantly broader than the FFHA, that's where that comes in. Right. Because California's FEHA greatly expands not only what is defined as a disability, and we're going to get to specifics on that right now, but also what kind of accommodations might be required.
That's right, yeah.
And if you're looking at the graphic that's on your screen now, you'll see that federal law, FFHA, is significantly more limited in a variety of ways. Sam, talk to me.
So, under the state counterpart of the FFHA, FEHA, unlike the federal law portion of it, which excludes conditions that are too temporary, mild, or not severe enough, FEHA actually interprets the disability to include conditions that are episodic, intermittent, or not even outwardly visible. And FEHA also includes as disabilities conditions that affect daily functioning, not just the extremes, right? That would be contemplated under FFHA. So even fleeting, intermittent, episodic, flare-ups would be qualified under FEHA.
And talk to me real quick. It's true, right? HOAs often try to defeat requests by arguing what? What do HOAs try to argue?
So they oftentimes argue that threshold. The residents and applicants who basically submit these requests for accommodations, that they don't meet the legally qualified threshold to satisfy disability requirements.
You're not disabled enough.
Right.
Or you're not...
and without being medical practitioners or clinicians themselves, they kind of assume that role and the rule of an arbiter in terms of what satisfies that threshold when they clearly... that would run afoul of the FEHA and the more broader interpretations.
So California law goes much farther than the federal law. So, in other words, under FEHA, the following conditions would constitute a disability where they probably wouldn't, or almost certainly wouldn't, under the FFHA. Right? For example, homeowner with chronic pain or arthritis who can walk short distances but can't safely navigate long walks from assigned parking that might be located 50, 100 yards away, whatever the case
absolutely.
is. Right?
Yep. Mm-hmm.
Or you might have a homeowner with migraines or some sort of vestibular disorder triggered by heat or by light or by sound or some physical exertion.
Under FEHA, that would be eligible, yeah.
But not necessarily under the FFHA.
Correct.
Okay? Or here's something else. A homeowner whose condition is controlled by medication but still substantially limits their daily activities when it's untreated or during a particularly rough flare-up, let's say.
They would absolutely have a good faith basis to apply for accommodations, and under FEHA, that's eligible.
Under the FFHA, those conditions that are managed by medication or those fleeting conditions might not be even considered disabilities within the meaning of that federal law.
Correct.
So when it comes to evaluating the accommodations as well, FEHA also goes much farther than the federal FFHA does.
It does.
And in California, I can tell you, or we can tell you, Sam and I can tell you from experience that California courts, when interpreting FEHA, are a lot less tolerant of rigid HOA reasoning. That sounds like the board is just defaulting to what the rule says, right? That's the rule, or that's the way we've always done it before, or that's just the way it is,
Not good
right?
enough. Nope.
And they get in trouble much faster under California's FEHA when our courts are interpreting our law as well. Now, so we've got through FFHA, we've gotten through FEHA. Now we get to the Davis-Stirling Act, which is very specific, relates only to HOA communities.
Correct.
Okay, and that's 4760 of the Civil Code. Okay, now 4760 is just it doesn't even have to exist, to be honest, because I think everything that needed to be covered in that is probably covered under FEHA, or at least the interpretation of FEHA by our courts. But Davis-Stirling Act has this provision, and it is very specific about the types of accommodations we referenced earlier. Even though the statute specifies kind of the interior, like making that lift, that elevator inside your condo kind of thing, that's the sort of in your separate interest. That's what that statute focuses on.
Right.
It's very strongly implied because of a couple of wordings, I think in subsection B, if I'm remembering it correctly, but I might not be. It also would apply to the handrails or the ramps that might need to be made in the common areas as well. But that's the statute that says the HOA might need to allow you to alter either your separate interest or the common area in order to effectuate some ease of whether it's mobility or whatever. You might need to make an alteration to your separate interests.
It's really an extension of the architectural review authority that HOAs have just generally, except for this extended.
Which is why that statute's located.
Where
if you look at if you look at where we've done previous podcasts, several on ADUs and architectural guidelines, and we've got at least a dozen articles on there if you add them all up.
4750, and it's right there consecutively.
Right, exactly. Yep. And so the fact that this one is in the 4700s, it's located right near the other architectural guideline ones. That's probably exactly why it's located
to provide guidance and more clarity to HOAs and boards.
Yeah. Again, there's nothing. We're not saying, we're not even remotely intending to imply that HOAs don't have the right to make sure that work is being done in a workmanlike fashion, that you're using licensed contractors, that the work is done well, that maybe even if it's common area, they have a right to inspect and to sign off on it. even though you're paying for it and it's your
And
contractor.
arguably require insurance, because if you have someone
100%
tripping and falling or
the
injured,
HOA might even, I would say, probably would have the right to determine if they wanted their contractor to do the work. It could probably do that, because it's at least to the extent that you're trying to modify common area. I think they'd have a right to say, you have to use our contractor in that case. That's not the case in your separate interest.
That's right.
Now, there's one other set of laws out there, folks, that board members and HOA members at large will routinely cite when it comes to accommodations and disability-related rights. And it's a mistake in 99.9% of the time, because this set of laws just doesn't apply at all. And the vast majority of people out there, whether they're members at large or board members, have no idea. And so you'll hear reference to this set of laws. And when you hear it, because you've listened to this podcast, you now know that unless it fits into one of these exceptions I'm about to explain to you, that whoever's talking doesn't know what they're talking about. And that is the Americans with Disabilities Act, or the ADA. So as a general rule, and I'm going to say, I say general, I'm being very generous, because in 99% of the situations, in 99% of the HOAs in California, and there are 55,000 HOAs throughout the state and counting, the ADA has zero application to the HOA at all, anything. It is wrong to cite the ADA. That's a real set of federal laws. There's some teeth to the ADA. But they don't apply in 99% of the cases. They do not apply to HOAs at all.
That's right.
Meaning any citation of the ADA is just dumb. There is one exception, and this is the only time the ADA would possibly apply to your HOA, and that is if your HOA hires out or allows non-members access to your amenities. For example, for those of you who live in Orange County in Southern California, which is where our office is located, there's a large community called Nellygale.
Right. Yeah.
Nellygale has a lot of horse trails. It was designed to be horse friendly, and many of the homes in Nellygale they're considered horse properties. So they're very large. They have, they're often more than an acre, and they have, the horse fencing and barns and all that sort of thing. And a lot of those are hired out. Those are private by the homeowners, so that wouldn't affect this. But some of those are owned by the HOA, and to the extent that members of the public are allowed to lease or rent space in those public areas, or even to bring their horses for training or riding, they would be subject, that amenity, the horse area that's owned by the HOA, would be subject to the ADA. Or the Nellygale pool. Most of the homes in Nellygale have their own pools.
Right.
But there's also a pool that's owned by the HOA. And you don't have to live in Nellygale to buy a pass to use the Nellygale pool. When I was living, we were waiting for my not the house I live in now, but the house before that to finish being built. We were staying at a rented condo, and my son and I were staying at a rented condo, and it had a pool in the community, but it was a smaller pool. I was a member of the Nellygale Tennis Club and Pool Club at the time, and so we would go to that pool all the time because it was only a minute and a half, 2-minute drive, and it was just a much bigger and deeper pool, and the tennis courts were there, so it was just great.
Yeah.
So I didn't live in Nellygale, but I had rights to access.
Right.
The pool area and the tennis court area and the facilities are subject to ADA because they open them up to the public at large to have use. Whether it's paid or not is irrelevant. Other than that, ADA doesn't apply.
Right.
Keep that in mind. You don't cite the ADA for your HOA unless you're a specific public, one or more amenities are open to the public. It just doesn't apply. Sam, I think this is a great place to stop today. I know it's a little shorter than normal, but we have a lot to cover. And I think I want to do it in one go. And we're going to start when we come back to our next episode, part 2 of this. We're going to start with, okay, we've talked about what the law is. Now, who's disabled and who's not? And again, we're going to be revisiting FFHA and FEHA because as it was before, it is now FEHA's definition of who is disabled or what constitutes a disability is more broad than the federal version, the FFHA. So when we come back in part 2 of this 2-part series, we'll start with, okay, under the law, who's disabled?
Sounds good.
Okay. If you liked part 1 of this episode, please hit the like button. If you haven't already done so, please subscribe to our channel, HOA Hell. you want to leave a question or comment, as always, we welcome those. Until next time, have a wonderful day.